Hi, I'm John McGowan, General Secretary of the Social Workers Union, and good evening and welcome to another SWU webinar where social workers get the opportunity to ask employment-based questions. And it really is, it's great once more to see so many people registered, and I can see a large number of attendees for tonight on screen, so thank you very much. I am hopeful that we will get through a lot of questions this evening, and do remember that the advice offered for this session is as of today's date, which is the 3rd of November 2021. The event is being recorded and it will be available to review and share very soon. Indeed, the last recording reached over 1,000 views, so thank you once more. Working behind the scenes are the talented and skilled Sean, Jane and Joanne, so thank you. I will now take you through some of the housekeeping for this webinar. Please ask any questions in the live chat box, which will be to the right of your screen, and Sean and Joanne will make me aware of them to share with the panel. And really, my advice is to keep the comments brief and non-identification factors in any message, just to represent confidentiality. So thank you. Before I introduce the panel, I just want to emphasise the need to join a trade union. Of course, I'm biased, and I would always recommend that you join the only specialist social work union in the UK, which of course is SWU. And again, SWU working with BASWA is indeed a terrific collaboration for the entire social work community. And in particular, I'm delighted that membership of SWU continues to grow, and we now have over 15,000 paid members in the union. So thank you, and a great achievement for us all in SWU in our 10th year. Why would you not want to join a specialist union, I ask myself. But now over to the most important people in this webinar, and I'll ask each panel member to introduce themselves, and I'll start with Paul. Paul, would you like to introduce yourself, please?
My name is Paul Scoley. I'm a solicitor and partner at the trade union law firm Morrish Solicitors. We're based in West Yorkshire, but we act for about 20 unions up and down the UK. And in my field, I work exclusively in the employment law and industrial relations area, and again, exclusively for employees and the trade unions who represent them.
Thank you, Paul. And over to you, Laura.
Hi, yes, I'm Laura Sheridan. I am one of the members of our advice and representation team here at BASWA and SWU. Good,
thank you. So we've had some questions in from attendees, so we'll start with some of them and then we'll link that with some live questions. So we had a question in earlier, and this question's, we'll start with Paul if that's okay with you, Paul. And the question says, could you expand on constructive dismissal, and is it a good remedy for my situation? So I don't know what that situation is, but could you expand on constructive dismissal, and is it a good remedy?
Happy to do that, John. It's a question I'm asked very regularly by clients, and I rarely have a satisfactory answer for them. Certainly not one that they want to hear. It's difficult as a lawyer to understand why it is that constructive dismissal has become a term that you can hear down the pub as often as you can in a legal office. It's a technical legal term, a term of art that for some reason has become known by every taproom lawyer in the country. And we hear again and again, I'm not happy at work, I've got a good claim for constructive dismissal because my pal has told me so. In fact, the usual answer to the question, do I have a good claim for constructive dismissal, is no, you don't. You can claim constructive dismissal only where your employer has acted in a way that represents a fundamental breach of your contract of employment. So something obvious like a cut in pay, I'm going to reduce your pay by 10%, is as plain a breach as you can get. But most people don't have obvious breaches of contract like that. Often what they're complaining about are relationship issues at work, or bullying issues that are not related to a protected characteristic that will be in play in a discrimination claim. So difficult to prove a breach of contract in many cases. Necessary before you can pursue the claim to leave your employment. So you need to quit, which means you're going to be out of work with only a potential claim that's not guaranteed of success. You need to quit quickly, so you can't hang around to see if the thing will be resolved for months. You need to get out of there very quickly, otherwise a tribunal will say, well, how bad was it if you hung around for 6 months after the things that had happened. You need to prove that the reason that you quit was the breach of contract with which we're concerned. So the resignation letter in these cases needs to be professionally drafted, is my advice, because otherwise the employer will point to your resignation letter and say, you never mentioned when you quit that your problems were caused by a breach of contract committed by us. So I'll finish with a small statistic that I think demonstrates how difficult these claims are. A few years ago, we totted up how many of these claims we'd run. We'd been referred 400 cases in a year that related to dismissal, and 4 of them were constructive dismissal cases. And out of the 4, we turned 2 down immediately, and we started tribunal proceedings for the other 2. And one of them we dropped halfway through, and the other one we lost. And that's how difficult it is to successfully pursue a constructive dismissal claim. So if you're told that that's a route for you, then firstly, doubt it. Secondly, get advice from your union about it.
Thank you, Paul. Anything to add to that, Laura? Are you happy with that?
I think that's a good answer. The one thing I would say as well is that at the moment, when people are bringing claims in tribunal, you're talking at least a year, 18 months, some people 2 years before their claim is actually getting to the tribunal. So effectively, you've quit your job and you're waiting 2 years before you get to court, and you've got no guarantee you're going to win. So it's a really, really risky situation to just hand your notice in and try and claim constructive dismissal. It's not a straightforward process, and not one we would generally recommend unless there was a really, really blatant breach.
Thank you, Laura. And I'm managing the chat here, and already we've had some vaccine questions in. So if you're thinking about that, then we were trying to answer that later on based on the questions coming in. But the next question I've got on the list, Laura, if you don't mind staying with you, and it's got to do with contractual changes. And it says, can my employer vary my contract without my consent? If you're happy to answer that one.
Yeah, and what I would say with that one is that good practice would be for an employer to discuss any variations that they want to make to your contract, to work with you if there's work with your trade union or union representative, particularly if there's a group of people having changes to their contract, collective bargaining. That would be good practice by an employer. And in an ideal situation, there should be a situation reached where if the employer has good reason for having to change your terms, whatever that reason is, there should be negotiation and there should be a middle ground reached, or something where people are not necessarily happy, but have reached a ground where they're satisfied that they can, accept those terms and conditions. In practice, if someone doesn't accept their terms and conditions, an employer can enforce a change in the contract, and unfortunately legally they are able to do that. They can simply enforce that change, and I think the important thing to say is if a change is enforced without discussion with you or without your consent, it's important at that point that you make it clear that you are not happy with the changes that have been made, because the longer you work on the new terms and conditions, the more it would be viewed that you're effectively accepting those terms and conditions. So the one thing I always say to people is that if there's something has been changed, you need to be making it clear from day one that you are not happy with the changes and you are effectively working under protest effectively. The other thing that has been in the news a lot recently, and probably lots of people have seen, is the whole fire and rehire tactic, as it is referred to in the press. And effectively an employer can choose, if nobody is accepting the terms and conditions, to dismiss someone and then reinstate them on their new terms. That is a risky tactic sometimes, because there's effectively potentially an unfair dismissal claim for an employee, but again, these claims can be quite difficult to bring, and it is a tactic that we have seen being used by all sorts of employees across the UK. Not so much so far, I would say, in our team in terms of social workers being dismissed and rehired. We've not seen that, so whether that will happen or not, I hope not, but it is something that can happen. And I think if we're in this, what I would say to people, if you're in a situation where there's any talk about any changes to your terms and conditions, get straight in touch with our team, because we can represent you through that process, we can advise, we can try and get the best out of that situation for you, really.
Thank you, Laura. Quality answer, so thank you. Paul, would you like to add anything to that, or just will we go to the next question?
No, I think Laura's covered that really well.
Perfect. So I'm just looking at the other screen. It says, my manager has refused flexible working hours. I have long COVID and need more flexibility. What are my rights regarding this? So again, my manager has refused flexible working hours. I have long COVID and need more flexibility. What are my rights regarding this?
Okay, well, the first thing to do is to look at your employer's own policies and procedures and your contract that might have some provision in relation to what you can do to seek flexible working. But let's assume that there are no procedures that you can use to go down that route. What does the general law say? Well, it gives you a right to request flexible working. But if you listen carefully to what that description means, it's a right to request flexible working. It's not a right to work flexibly. And the two things are miles apart. So in practice, this is a toothless right, because if the employer has their act remotely together, and 99.9% of HR departments will have their act together, they can very easily find reasons to turn down a request for flexible working. So it becomes for the employer a process. And provided that they tick the boxes and jump through the hoops, they can refuse a request for flexible working with impunity. So that's the starting point. General flexible working rights are poor. The government is currently consulting about extending those rights. But frankly, the consultation is plainly not going to introduce a right to work flexibly. It'll remain a right to request. So it will remain toothless. However, if your need to work flexibly arises because of a protected characteristic, and the two that most readily spring to mind are sex and disability, then it may be that you've got a different way by which you can seek flexible working arrangements. So very briefly, if, for example, you have childcare commitments that mean that, for example, you need to work different hours that are fitting for your childcare commitments, then it might be an act of sex discrimination for an employer to refuse to enter into a proper dialogue with you about working flexibly to reflect those commitments that you've got. There's been a recent tribunal case that has recognised that, as a rule, women are more likely than men to have the bulk of the childcare responsibility, and as a result, a working pattern that makes childcare more difficult indirectly discriminates or is liable to discriminate against women who will be disproportionately affected by that sort of pattern. And secondly, in relation to the disability area, people who have disabilities as defined in the Equality Act 2010 are entitled to say to their employers, I need you to make reasonable adjustments to the way I work. And one of those reasonable adjustments might be to work flexibly in relation to your hours or days of working, and provided that the adjustments that you're requiring are reasonable and are reasonably necessary to achieve your best manner of working, in other words, to enable you to cope with work despite your disability, then the employer who refuses to give you that flexibility will potentially be liable for a reasonable adjustments claim in the employment tribunal.
Perfect. Thanks, Paul. And there was a live part to ask you to expand, just to say that is long COVID classed as recognised as a disability, and I think you've answered that. So, Laura, anything you would like to expand on that?
Yeah, I think Paul's covered most of it. I suppose picking up on the long COVID being classed as a disability, it depends on, a disability is defined as something that's has a substantial impact on your daily life that's lasted or likely to last for 12 months. So it's early days in terms of whether or not we see whether long COVID is being classed as a disability, because those cases haven't got to tribunal yet, and I have no doubt at some point they will, or that, you know, they'll start coming through. But yeah, I think if someone's symptoms are so they're having such a big impact on their day-to-day life, then it is highly possible that that could be classed as a disability. But ultimately, that's for the court to decide.
Yeah, thank you, Laura. And there's two live questions, are quite similar, so I'll kind of I'll try put it together. So the first one is, I'm being bullied at work by the senior social worker. What can I do? Another one's quite similar. The live one that's came in just now. It says, my manager is constantly finding fault in my work, and it's affecting me mentally at times. I feel I'm bullied. How can I deal with this? So they're quite similar, asking what can I do about it. So
Okay, I
that's
think
for you, Laura. Sorry.
Yeah, I assumed it was. Sorry. I think it's a really these kind of situations are really, really difficult. We advise members quite regularly on this kind of issue in terms of difficulties with management styles, feeling bullied, feeling overwhelmed, and there's a whole host of things that come into that, really. I mean, the one thing I would always say to people is you need to try and do your best as much as you can to try and resolve things informally, which is far easier said than done. I'm aware of that, but sometimes if you can resolve it informally by, you know, maybe trying to speak to your manager first, if that doesn't resolve things, speaking to their manager, arranging three-way meetings can sometimes help. Mediation, if you can ask for mediation between your manager to try and get that kind of situation resolved as much as you can, then you can at least demonstrate that you've done everything you can to try and resolve things informally before trying to take any, I suppose, formal action. The other option you have is raising a grievance about the way you're being treated by your manager, if it is to that severe level that it's having a severe impact on your day-to-day health, well-being, your impact on your work, because you can feel it can affect your practice if you're constantly feeling under scrutiny, and that's a real big issue, I think, for people. So I think what's really important is that if this is something that is an issue for you, you need to ring and talk it through with us on the duty line, because we can try and pick out sometimes certain things that are happening that may relate, going back to the whole you know, the Equality Act issue. There could be issues with protected characteristics. For example, you know, we speak to, I would say, proportionally far more staff members from ethnic minority groups that are going through issues of bullying and extra scrutiny in the workplace, and I think that's the kind of thing that we can explore with you further, support you of how to approach that, challenge that, and there becomes another issue that we can offer advice and representation within that area as well. So I think ringing and talking to us about what the ways of managing that are, and potentially raising a grievance and what that process is and how we can support you with that is really important.
Thank you, Laura. And as General Secretary of the union, I'm always in awe of the great knowledge base of the advice and representation team. So, you know, once more, a terrific answer. So, thank you, Laura. And Paul, would you have anything to add to Laura's answer?
Laura's answer is a really good practical pointer to what to do if you're facing that issue. But it's interesting how lots of these questions start to merge together, and we go back to the same principles. Sometimes there's again a misunderstanding, I think, often amongst the public, that a claim can be made for discrimination or victimization, as people often call it, or bullying in its own right, and that's not the case. The tribunal system is set up under the Equality Act 2010 to hear discrimination claims that relate to one of the protected characteristics. So if it's about your sex or race or disability or religion or age or whatever, then yes, if the bullying is a form of excuse me, harassment related to a protected characteristic, a tribunal claim might well arise. But in many cases, it's not. It's about personalities, or it's about an overbearing manager, or a failure to support, and so on. And in those cases, we go back to the very first point that we dealt with in relation to constructive dismissal. And that might be the only remedy you've got, which is a rubbish remedy, because it means you've got to leave your job. And I've already said so few of these cases actually result in a success for the employee, but the law doesn't provide us with another remedy. So I go back to Laura's point, that try and resolve the matter internally, because if it can't be resolved internally, the legal avenues open to you are really restricted. And it's not good, it's not the way it should be. And in my view, employees ought to have better rights to find a way legally to seek redress for bullying, because bullying that's not related to a protected characteristic can be just as painful and difficult and frankly health threatening as bullying that is.
Thank you, Paul. And
I think, John, I've just noted that the person that asked the question has also expanded to say that they are also new to the UK. So I think that kind of expands on what I was saying in terms of potentially someone being from an ethnic minority group. And I don't know, we don't know the answer to that, obviously, but I think I would urge that person, because we can't get into specifics on this webinar, we obviously just answer general questions, but ring our duty line, we will book you an appointment and we'll explore what's going on further and offer you the advice that we can offer to help you try and resolve that.
Yeah, and obviously you can still join SWU and BASWA and be offered advice from that point. It's just a representation. You might have to wait 3 months, so you could always access advice. Paul, a very topical questions came in. It's surprise, surprise, it's about vaccines. So I'll read this one out to you. It says, I have made a decision not to take the vaccine on health grounds. What can I do to protect myself and others at work? Or can my employer insist on the vaccine even though I'm not visiting care homes? So again, I've made a decision not to take the vaccine on health grounds. What can I do to protect myself? And can the person's employer insist on the vaccine even though he's not, or he or she's not visiting the care homes?
Yeah, thanks, John. This is obviously really topical and really difficult to advise about, because we don't really know yet what view the courts and tribunals are going to take in relation to people who resist vaccination. My suspicion is, but this probably says as much about my personal opinions about the whole issue as anything else, my suspicion is tribunals and courts are going to be fairly sympathetic with an employer that comes before them and says, well, we've had to insist on vaccines because we're trying to protect the workforce, especially if that employer has gone to the trouble, as I know some employers are doing, of getting expert occupational health advice to say, these are the steps that you should take to protect your workforce. So I think somebody in that position probably starts on the back foot. I think they're going to have a hill to climb to persuade a tribunal that they're protected. But that said, there are steps that can be taken. So raise the thing firstly from a practical point of view with management and say, look, these are the reasons why I don't want to get vaccinated. And these are the steps, be proactive and suggest these are the steps that I say I can take that will enable me to work with my colleagues in a way that's safe for all of us. And that might be working from home, and it might be that you can work from home. It might be the use of masks and social distancing, other COVID protective measures will be sufficient depending on the way that the office environment is set up. If the management's not going to listen to that, lodge a grievance, take the thing through a grievance procedure, again with the support of your union and your A&R reps who will advise you right through this process, but who can't, I'm afraid, give you any guarantees about where it's going to end up, because in the end, I suspect, well, we've seen it already, some people are being told, well, unless you're prepared to do X, Y, Z in relation to vaccination and masks and the rest, then your job with us is no longer secure. And very difficult at this stage to say that necessarily you'll have any comeback in relation to that if you're dismissed for failure to take what the employer says are essential steps for health and safety. Let me add a caveat, and nearly all these questions have the same kind of caveats in relation to disability. So there will be people who, for all kinds of reasons, but especially people who, for medical reasons, are told not to get the vaccine. So employers are going to have to look at making reasonable adjustments, as we talked about earlier, in relation to people in those circumstances. It's been suggested that some people might have religious objections, say, in relation to vaccination, although I'm not aware actually of any major religion that has come out with an anti-vax stance. So I suspect that that's not going to fly. Disability is probably where it's about. One of the other issues that I'll just throw in there is that the evidence suggests that members of ethnic minority groups, in particular the Bangladeshi and Pakistani communities, seem to be at much higher risk of death or serious injury, as do men, compared with women, regardless of ethnicity. So the Welsh government has set out some advice now on its COVID-related website, talking about how employers might be expected to go the extra mile for people in minority groups who are particularly susceptible to COVID or to hospitalisation or death as a result of it. So really difficult stuff, really current. We don't know where it's going to go. So I caveat what I've said, their best guesses. That's all we can do right now.
Thank you, Paul. And hopefully I'll be shared. I've just shared, and this will be coming to attendees, the BASWA and SWU statement on compulsory COVID-19 vaccination. So you can have a read of that, any attendees on live. And Laura, anything you want to add to that question?
No, I think Paul's covered that well.
Yeah. So well, I'll keep you there for the next one. We've got lots of questions in still, so that's really good. So thank you. And it says, my manager is questioning my performance. I have worked so many extra hours to get the work done, and she is saying that she's going to consider an informal action plan. What does this mean, and what are my options? So the manager's questioning the performance, an informal action plan has been suggested.
Okay. I think the first thing I would say with regards to that is obviously that this person is saying that they've worked lots of extra hours to get the work done. Ideally, and we all know this doesn't happen in social work, but you shouldn't be working excessive hours every day, all day. The hours that you are given should be the hours that you can get your work done in. Now, practically speaking, I'm saying that I've worked as a social worker for many years. It wasn't your typical 9-to-5 job. And of course, you have days and times where you're working till late and you're doing those extra hours. But if you're doing that every single day just to keep on top of your workload, there is a question there about whether your workload is appropriate and manageable, because every social worker should have a manageable caseload. Otherwise, it becomes dangerous on all sorts of levels, not just for yourself, your health and well-being, but actually for those people that you're supporting, because you can't provide an effective service if you've got too heavy a caseload. So it's about kind of exploring that, and I'd like to explore that more with the person again on our advice and representation duty line in terms of what the actual workload is. Going on to the performance issues, now that sounds like it's going, the manager is going down a route that is referred to generally as a performance capability route. The first thing I would say to anyone who's been spoken to about performance issues and about going on any kind of informal plan is to ask for a copy of the performance capability procedure and process, so you know exactly what it is your manager is supposed to be doing and what process is supposed to be being followed. Now, at the moment, it sounds like they are going through an informal process, which means you're not on any formal route of where your capability is being monitored and extra support is being put in place, which is what happens when you start going down that formal route. It is basically a more formal route. And the informal stage tends to happen before that, and what should be happening is your manager should be sitting and talking to you about what their particular concerns are about your practice and formulating a plan. And that plan shouldn't just be about them saying what they are concerned about and what they think you need to be improved on. That should be about what they are actually practically going to do to help you improve with your performance. If there is an issue, there may, a lot of the time people don't believe there is an issue, and there's a whole debate about that. But the plan should be about support for yourself. And if you're saying that your workload has been so excessive that you're working extra hours to get the work done, one of the first things that should be put in as support is actually, let's make this caseload more manageable. That's the first thing that's coming to my head in terms of getting that informal support plan drafted. So if you go to a meeting with your manager, I suppose you need to have ideas in your head as to what you think needs to be done to enable you to do your job as effectively as you can. If you've not been able to do it effectively because they're giving you too much work, well, that needs to be said in that informal meeting. If it starts going down a formal route, then you are entitled to representation. So again, I would say get in touch with us initially for advice, even on the informal side of things. But if it starts going down a formal route, some employers will allow us into informal meetings, in all fairness, but a lot of them don't. They only allow representation at formal capability meetings, which is why it's important to get the policy, because then you can see what they are going to allow in terms of representation. But if it starts going down a formal route, what they should be doing is reviewing this informal plan. If things are sorted out, then that's it. Job's done effectively, and the capability route is finished. If they say no, we need to now go down a formal route, at that point 100% get in touch with us, because you should be entitled to representation with that, and we can then talk you through what to expect moving forward and how to manage that, really.
Thank you, Laura, and we'll just go to the next question if that's okay, Paul, unless there's anything you wanted to add to that.
I was going to just say very quickly this, John, that do get advice, as Laura says, as quickly as you can about if you're performance managed, because in my experience over many years, there are not many employees that an employer that's determined enough cannot performance manage out of an organisation if they really want to. So getting your act together really early on, making sure that you get all the tips and advice from the A&R reps is absolutely crucial, because halfway or 3/4 of the way through the process, you might be in an irreversible position.
Thank you, Paul, and I'll just keep you there for the next one. It's my manager refused annual leave during half term. What are my rights and what can I do?
Right, so the starting point with all of these things is look at your contract of employment and look at any policies or procedures that the employer has in relation to holidays. So start with that, and it may be that you've got a right to insist on taking holidays at certain times. But again, I'm going to assume for the purpose of this answer that there's no such specific provision in your contract or handbook or whatever. What does the law say generally? Well, it's not terribly helpful, unfortunately. The working time regulations say how you can choose your holidays and what the employer can do in relation to your choices. So the starting point is that if you want to take holidays at a certain time, you can say to your employer, I'd like to take this week off as a holiday. And you do that by giving a period of notice that's at least as long as the holiday you want to take. So if you want to take a week off, you'll have to give at least a week's notice. The employer then can give what's called a counter notice and can say to you, well, actually, you can't take that week off because it doesn't fit in relation to my organisational requirements. Somebody else is booked off or whatever. But in fact, the employer doesn't have to give chapter and verse about why it is they're being difficult. They can simply say, no, you can't take that time off. And there's no easy comeback to that. If the employer continues to do it, then over a time, eventually, you'll have a right to complain to a tribunal that in practice, you're being prevented from exercising your right to take holidays. But if it's an occasional issue where the employer simply exercises the right to give notice to prevent you exercising your right of choice, then it's difficult to do anything about that. Practically speaking, what do? Speak to the union straight away. Again, they can give you advice about this. You can pursue a grievance if necessary internally, try and negotiate an outcome with the employer that everybody's happy with. So there are practical steps that you can take, but legally your options are fairly limited unless your contract says that they're not.
Thank you, Paul. That's excellent answer there. And Laura, anything to add to that?
No, I think Paul's covered it all.
Perfect. So still several questions to go and they keep on coming in. So as always, a popular session in this webinar. So the next one, I'm just reading the screen now. It says, I have dyslexia. I have asked for, and this is for you, Laura. I have dyslexia. I have asked for readjustments, but the IT department do not fully understand my needs, and it has taken a very long time to get in place. What can I do? So I have dyslexia. I've asked for readjustments, but the IT do not fully understand the needs.
Okay, the first thing I would think about with that is if you've had dyslexia, have you, the clear point there is that they're saying IT don't understand their needs. Has there actually been an assessment of what your needs are? Has there been a conversation with you as to what your needs are? Quite often when someone commences their employment, there will be, if they declare a disability, which dyslexia can be classed as a disability, then the employer will refer to occupational health for a more thorough assessment to get some more information that can help establish what adjustments will be needed. The other thing that's kind of springing to mind with this, which I think would probably be quite helpful in this case, and I don't know if this has already been done, but we tend to advise members to get in touch with Access to Work. That is a government funded scheme where an assessor will do a complete assessment of your condition. In your case, obviously the dyslexia, they would do an assessment of what your needs are with regards to the dyslexia, how that actually impacts you on a daily basis, because the problem with any health condition, but particularly with dyslexia, is one person is very differently impacted by dyslexia compared to another person. So the actual needs of that person need to be established. Access to Work are really good at doing a thorough assessment and doing a thorough report for the employer as to what actual equipment, adjustments, etc. will be needed. And quite often on reports I've seen Access to Work to do on people who have dyslexia, they advise the employer as to how their condition is likely to affect them practically in their work, and advise particular training that employees can do to help them to organise their workload or whatever it is that person is struggling with regards to their dyslexia. And they sometimes recommend and provide grants for management and to go on that training in terms of that awareness of those needs as well. So it's a really good resource, and it is really helpful to help make sure that your employer is fully aware of what is needed. And all you need to do is literally Google Access to Work. It takes you to the page and you can yourself refer for that service. So I would 100% recommend somebody do that. I think if there continues to be a problem, and equipment isn't being provided, don't delay and get in touch to ask for advice, because there's a potential there, and I'm only saying potential because we need to obviously explore it further, but potential disability discrimination if adjustments aren't being put in place for someone who has a condition that could be classed as a disability. The longer you leave it, the less likely you will be to have a claim, because there are 3-month time limits for employment tribunal claims. So one of the things I would say is, if there is an issue that's ongoing, get in touch with us sooner rather than later, because you wouldn't want to be out of time for any potential claims if there was one.
Thank you, Laura. Well done. And Paul, anything to add to that?
No, I think it's a good answer by Laura.
Perfect. So we'll move to the next question. Again, it's vaccine related, and I'll read that from the screen. It says, what are we supposed to do if we are visiting a service user who's strongly anti-vax and has not had vaccinations or doesn't use masks? Are we, and the person says as social workers or advocates, able to refuse to meet with clients in these circumstances, even when our own means of communication with them is face-to-face? So happy to read that again, Paul, or did you get the strand of that?
I've got the gist on it. Obviously, we've covered some of this in the earlier question in relation to, what's the position at work, and the same sort of considerations apply. We've already seen some cases coming through in the tribunals, but not so much the appeal tribunal yet, in relation to people who've said, I'm concerned about the circumstances in which I'm expected to work because I fear that I'm going to come into contact with people with COVID. There's an interesting employment tribunal case that you can look up, in fact, on Google, called Ham, H-A-M. Mr. Ham was a driver who was asked to go to his manager's house to take some equipment to the manager, but the manager was self-isolating and admittedly had a bad dose of COVID. So the driver, Mr. Ham, said, well, no, I'm not going to go to that house because I'm scared for my health and safety. But he offered, to be reasonable, to take it to a midway place where he could drop it off and where the manager then could arrange for somebody to pick it up. But the employer didn't like that, sacked Mr. Ham, who brought a claim for unfair dismissal in the tribunal, and I think not entirely surprisingly, succeeded with that claim. Under sections 44 and 100 of the Employment Rights Act 1996, you have a right to remove yourself from a workplace or to take other steps, such as Mr. Ham did, if you fear that your health and safety is in serious and imminent danger. And I think, given the events of the last 2 years, it's very hard for an employer to argue that the threat of coming into contact with COVID isn't a serious and imminent danger. And provided you behave reasonably and you look at the steps that you can take, and it's interesting that in Ham's case, he did suggest, look, I'm not simply saying no, here's an alternative way to go about this that still respects my health and safety, then the law will be there to protect. And I think there's a pretty good argument to say if people are not being vaccinated, are not prepared to wear masks, and are not prepared to take any steps to be socially distant from you, then expecting you to go into their home environment where you're up close and personal might well represent a breach of sections 44 and 100. I say might well because, as I said earlier, and I think Laura agrees with me, we're not quite there yet. There's the odd case like Ham that shows in fairly extreme cases the tribunals are going to take a view. But at present, for example, in England at least, although it's different in Scotland, masks are no longer mandated. And if the government's not mandating masks, is an employer going to hide, in effect, behind that to say, well, we can't expect people to wear masks? We've not yet got a mandate, say, in relation to care homes for vaccination. Is the employer going to hide behind the government's inactivity in relation to that, especially when we've seen a bunch of politicians in Scotland and in the House of Commons recently not wearing masks? So difficult to know what the employers are going to do about that, but certainly lots of arguments to be made under sections 44 and 100 of the Employment Rights Act 96. The two sections cover different things. One deals with dismissal and one deals with being subjected to a detriment. So if you're demoted or threatened with a pay cut or disciplinary proceedings, even if you're not sacked, the Act can protect you, and the Act extends now, since recent changes in the law, not only to employees, but to people who are workers, so who fall short of full employment status too.
Thank you, Paul. And Laura, would you like to expand on anything from that point?
The only thing I would say is, again, reiterating, if you have this issue, if you are being demoted as a result, if you're facing disciplinary action as a result of refusing to go into a situation that you believe is unsafe, get in touch with us sooner rather than later. Even if you're a new member and aren't entitled to that representation, because you have to have been a member for 3 months for that representation, we can advise you. And it's about, again, if there is a potential claim in an employment tribunal for anything to do with the health and safety, you've only got 3 months to bring it. So you need to get the advice and the representation if you can as soon as possible, because the longer you leave it, the less likely you'll have any kind of legal recourse to challenge that.
Thank you, Laura. And it's hard to believe, but we're now up to question, I think this is number 10 already. So it's, you know, when you're getting through some quality answers, and I've got a few more in, but there's probably still room, I think, between now and the end of the webinar if anybody's got any other urgent ones. And don't worry, if your question's in, we will get round to it, but I've added it to the list. So Laura, if you don't mind, I'll stay with you for the next question, and it's I want to go part-time. What is the process of requesting to reduce hours due to child and caring commitments if currently full-time? So again, it's I want to work part-time and they want to reduce the hours.
Okay. Generally speaking, somebody has the right to request flexible working. I can't remember the number of weeks that you have to have worked for an employer to do so. I want to say 28, but it could be slightly different off the top of my head. But you have to have worked for an employer for so many weeks until you have that legal right to request that flexible working. Although a lot of employers will allow those requests from day one. In all fairness, I know I've attended interviews in the past and asked for the flexible working and got that flexible working before I've even started the job. So some employers are more, I suppose, flexible than others in terms of that. But what I would say is the first thing to do is to get hold of the employer's flexible working policy. They will have a flexible working policy. They'll probably have a form that you have to fill in or some kind of process where you have to inform your manager as to your request for flexible working, what your hours you're requesting, your working pattern, and they'll often ask for your reasons for that. And I think if it's quite important that you put your reasons in there in terms of needing that flexibility for childcare arrangements, because that's quite significant. Hopefully the employer will then look at that and grant it, and then all is good. Legally, they do not have to grant your flexible working request, but what they legally have to do is show that they've reasonably considered your request, and they do have to give a genuine reason as to why they can't grant it. A lot of the ones that we see when we're representing people are that it's effectively it doesn't, they're not able to run the service with the hours that you've requested. It's a business reason, as it's referred to legally, but that means that if you were requesting 2 days a week, quite often if someone's requesting 4 days a week, the employer will often say, well, no, that's not very easy for us to facilitate, because we've then got a social worker that's one less day, and it's difficult to recruit a social worker just to cover that day. So that's the kind of thing that an employer could be viewed as being reasonable for refusing that request, but they have to give a reason for why they've refused it. And an employee does have a right to appeal the outcome of that decision, and again can state their case as to why they believe that they should be, you know, provided with that flexible working arrangement. Again, if you can get representation with that from us, please do, because we can advise you with that. We can support you to make sure you state your case. And if an employer doesn't reasonably grant a request, or there's a potential for there is the potential for a tribunal claim if it's not granted and it's unreasonable for them not to grant it, which is why, again, I say, you know, speak to us sooner rather than later. These claims aren't always easy to bring, so I'm not sitting here saying you would have a claim, but obviously what I would say is the sooner you get that advice on that, the sooner we can support you with that.
Thank you, Laura. Anything to add there, Paul?
No, good answer, Laura. Thanks.
And just to clarify, I think it's 26 weeks for the request as well. So you're
I wasn't far off then. I wasn't far. I think I said 28 weeks. I knew it was something like that.
Good. Next question there is, again, quite a topical question, because last week was National Menopause Week, and the question relates to, is there any legal protection for people who experience the menopause? And if you don't mind answering that, Paul, if that's okay with you.
Yeah, thanks, John. It is topical, and it's just come to an appeal tribunal for the first time that I'm aware of, anyway, in literally the last few weeks. So we've got some judicial authority now that that looks at the question of what protection the law offers for people who experience the menopause. So the first thing to say is that the menopause per se is not protected in law, and in that respect, this kind of links into the long COVID question that we had earlier. The word itself, menopause, just like long COVID, is not defined in the Equality Act as a disability. So what you have to look at is what the symptoms are, whether we're dealing with long COVID or the menopause. But in this case that's just been decided, what the appeal tribunal said is the tribunal failed to look at whether the symptoms that the claimant complained of might indeed have amounted to a disability under the 2010 Act. And as Laura said earlier, that the definition of the legal definition of disability is straightforward. Do you have a substantial physical or mental impairment that has a long-term effect on your day-to-day activities? So the effect need not be enormous. It needs to be more than trivial. So things that only affect you in a trivial way will not qualify as disabilities. The thing has to be long-term, which means longer than 12 months, and it has to affect your day-to-day activities. So if the only thing that your disability affects is your ability to perform piano as a concert pianist, then that's probably not regarded as a day-to-day activity for everybody. But otherwise, it seems to be absolutely possible, and the EAT have said as much in this recent case, that the symptoms that together make up what for many people is their experience of the menopause may amount to a disability, be they intolerance of temperatures or tiredness, lethargy, feeling ill, whatever the symptoms are. If together it can be shown that they qualify as a disability as defined in the 2010 Act, then absolutely disability discrimination protection may apply. And there's a lot of lobbying going on in the background, I think, and certainly I think the House of Commons Women's Committee has been pushing along this line to say that there ought to be more specific support for people with menopause related issues, and that legally, in the same sense as we've said, perhaps long COVID should be recognised without more than perhaps the menopause should be recognised too, as an issue that requires specific protection.
Thank you, Paul. And anything else to add to that, Laura?
I think Paul's covered that.
Good. Only a few more questions I think we've got time for. The next question is, I have a diagnosis of ME CFS. I've been working 4 days a week as a reasonable adjustment, but now being told I can either do full or half time. Wondering what is the definition of reasonable adjustments in cases of disabilities, or whether I need to find another job that can offer the 4 days. So again, the diagnosis and the reasonable adjustment. Is that okay, Laura? Do you want me to go over that one again?
Yeah, no, that's fine. I think I've got my head around that one. The first question springing to mind for me, and I actually did represent somebody last year at some point with a very, very similar situation to this, who'd been working 4 days a week, actually spread her full-time hours from over the full-time over 4 days, and suddenly was told that that wasn't going to be, they weren't going to be doing that anymore, and every single person in the team was going to be working Monday to Friday, 9 till 5 or whatever the hours were. The first thing that sprung to mind for me was this had been an arrangement that had been in place for quite a long time for this particular member of staff. And the first thing springing to mind with this case is, why have we been able to allow this reasonable adjustment for this length of time, and now we're suddenly saying that's not an option? Because there doesn't seem to be any business reason screaming out to me at the moment, because you've managed it for this long, so why do we suddenly have to change that? And the employer may have an argument, it may be reasonable, it may not, I don't know, without delving into that. But what I would say with this case we're talking about now is that actually the employer does have a duty to make reasonable adjustments for an employee who has a disability. It's likely that those conditions would class as a disability, again depending on, it's not about the diagnosis so much, so it's normally about how that impacts on your day-to-day living. But let's say that it's likely that this is going to class as a disability. The employer has a duty to make reasonable adjustments, and in terms of a definition, I don't have my legal book in front of me to give you the legal definition, but what I would say is what that means is that they have to make adjustments that would be viewed as reasonable. So they couldn't make something, if something was virtually impossible for them to do, was ridiculously expensive, didn't fit with the service, they could argue that that wasn't reasonable. But in this case, changing someone's working hours to enable them to work on an equal footing to their non-disabled colleagues, to me seems like a reasonable adjustment. The fact that it's been in place for this long and now is suddenly being stopped is questionable. And I think the case in which I represented last year, it took us a month or two, but actually the end result of that was that the person did remain on their 4-day working week, because it was highlighted of the fact that actually potentially to change this without good reason for doing so, when that situation, that arrangement's been in place for so long, could easily class as disability discrimination. So you need to examine the circumstances really, and what the employer was saying in this case, to establish whether what they were saying was reasonable, whether it had just come out of the blue. So again, I would say get in touch and get that advice sooner rather than later, because we can help you to discuss that with management, help you to negotiate that and get the best outcome for you.
Okay, that's fine, thank you. I'm just going through some of the other questions there. So anything to add to that question, Paul? We've got quite a number of questions in, so we'll definitely not have time to answer them all, but any other points regarding the last question?
Sorry, I muted myself. No, Laura's answered it really well again, if I can say so. Sorry, Laura.
Good, and I'm just going into the next question now. So again, it's for you, Paul, but you might need some, I'm just going over that, you might need some support with Laura. But again, it's social worker has had their car vandalised while undertaking a home visit. The employer insists they have to claim on their own insurance. Does the social worker have any redress? So Paul, if that's okay with you.
Yeah, interesting one, John. The starting point will be, what does your contract and your employer's policy about car use say? And the answer will probably, or at least possibly, be found in those documents. If it doesn't, then it seems to me that there's an argument to be made here that this is work that you're doing on your employer's time and at their request. It's not social or domestic travel. Hopefully you're insured for business use, because if you're traveling to and from a client's house, then probably that's business mileage. But you can be disadvantaged if you're making a claim on your own insurance. That'll probably affect your no claims discount. It seems to me my starting point would be to say to my employer, well, why should I have to take the hit in my pocket in relation to that? I'm doing what I'm doing as part of my employment for you. But as I say, the practical point is probably that the thing will be dealt with in a company or private car policy that will be in or incidental to your contract of employment.
Thank you, Paul. And Laura, would you like to add anything to that one?
Covered that, I think, Paul. That covered that well.
Good. And just going over, there's so many questions in, so it's making, there we go. So the next one is, if you resign and state you have been constructively dismissed, this is for you, Laura, does the local authority have a duty to investigate the claim? So if you resign and state you have been constructively dismissed, does the local authority have a duty to investigate the claim?
I'm not sure entirely. Sorry, I'm not sure entirely what is meant by the question. If they resign and say they've been constructively dismissed, the local authority doesn't particularly have a duty to investigate the fact that the person is saying that. I think in terms of if the person chose to actually bring a claim for constructive dismissal, then if they brought a claim in tribunal, then the local authority would have a legal duty to respond to that via the tribunal process. But generally speaking, from my knowledge, and it's difficult because I'm not 100% sure what is meant by the question, but they wouldn't have a legal duty to investigate anything if they'd just said I've been constructively dismissed, and that's what you've said. They could have a legal duty to investigate some things if someone said they've been dismissed because of whistleblowing, for example, but without knowing the full details of why they are saying they've been constructively dismissed. It's difficult to know what that duty would be. I don't know if you've got any more thoughts on that, Paul. It feels like I've not really answered that, but
No, I thought it was a valiant attempt. I think the short answer is no. There's almost certainly no legal duty to investigate it. If an employee resigns and says, "I believe that I've been constructively dismissed because I'm resigning in response to your breach of contract," then as a matter of good practice, a decent employer would want to investigate that and find out why. But is there a legal duty or obligation on the employer to do it? No. And some employers will say, "Well, you're out of our hair now because you've quit,"
yeah,
which is part of the problem of the constructive dismissal legal regime.
yeah, absolutely.
Thank you, Paul. And time is tight, so if you don't mind, Paul, I'll get you to answer the last question. There's a number of other questions still there, but I would advise anybody, if they are a SWU member or the BASWA member, they can contact Duty to maybe talk over it in detail. Or if you're not a member, they can maybe think about signing up and seeking out some advice. So there's opportunities there. And the last question that's around, somebody's asking about settlement agreements and to find out how they are used and if they're effective. So Paul, if you wouldn't mind concluding on settlement agreements, and maybe Laura, you could add to that as well. So over to you, Paul.
Thanks, John. Settlement agreements used to be called, if you've been around as long as I have, compromise agreements. So you might have heard them referred to as compromise agreements, and they're pretty commonly used now in most workplaces. And they arise for this reason. The law says, as a general rule, that you cannot give away your rights to pursue a claim against your employer in, say, a tribunal. And it says that it prevents you from settling your claims because it's trying to protect you from an unscrupulous employer who might sack you, write you a cheque for £500 and say, right, never darken my door again, that's the end of our relationship. So the law gets round that sort of unscrupulousness by saying, well, you can sign whatever you like, but you won't be bound by it. So you can pocket the money and still sue the employer. And that's great, and that's good protection for employees, but there are lots of circumstances where, often with the help of a union, you do negotiate exit terms in relation to your employment, and you actually want to come to a binding agreement with your employer, perhaps because they're paying you enough money to make it worth your while to leave. So the compromise agreement, now settlement agreement, was invented to solve that problem, that the law says you can't give your rights away, but you've negotiated a deal and you want to give your rights away, and the employer is not going to write you a cheque unless you do. So for a settlement agreement to be effective, it has to tick a number of legal boxes. The first is that it has to contain certain jargon, certain specified statutory wording. And secondly, you have to be advised upon it by what's called a relevant independent advisor. That's often a solicitor, it might also be a trade union rep, and that person has to be independent of your employer and insured in relation to the advice that they give. And in the case of a solicitor, they have to be a qualified solicitor, and for a union rep, they have to be certified as qualified to give that advice. And provided all those boxes are ticked, then the agreement, when it's signed, will represent a final and binding settlement between you and your employer. You can get advice again about this via the union. These things are very commonly used, and they're a useful way to pull together an agreement about either departing employment or perhaps in some cases settling a claim, for example, a discrimination claim that's arisen during the course of your employment.
Thank you, Paul, and almost bang on time, but it's 1 minute if you want to expand on anything there, Laura.
I was just going to say we offer advice and representation and negotiate settlement for agreements for members quite regularly in our team. You know, if it's something you're thinking about, get in touch. The one thing I was going to say as well was we don't get major amounts of money from employers nowadays when we're trying to get settlement agreements. I didn't want people to think we were going to be able to, you know, negotiate £100,000 settlement for them. We don't get it. Councils are cash strapped, so we have to do a lot of negotiation. But sometimes they're just the right thing for the person to be able to take the whatever that they get, and a reference, which is really important for social workers, which can be part of a settlement agreement, and then we're able to move on and help someone move on to a better place in their employment.
Thank you, Laura. That was a great finish. I'd like to thank everyone behind the scenes for helping with the webinar. I'd like to thank the panel and also the attendees. And if you're looking at this webinar later on for watching it as well. So thank you, and that's been Talk to SWU, and good night.